Thank you so much, guys. I greatly appreciate you guys hosting this talk and my opportunity to talk to all of you about this subject of civil commitment processes as it relates to case managers and community partners in the attempt to help individuals who are struggling with mental illness and numerous other types of stressors and challenges in the aging population. You'd only have to look around to see all the stressors that are going on right now for everybody. And of course, these are impacting all the folks that you choose to serve and have served all of your career. And I want to thank you for that work as well, because I know how challenging that can be. So just thank you for your service. Thank you for your help. And I hope you're taking good care of yourselves as well. As I launch into this training and PowerPoint, I'll stay on subject, but so I wanted to just take a moment to say how important it is that you practice good self-care and care of each other as we work through these difficult times. So again, thank you and take care. My name is Terry Schroeder, and I'm a Civil Commitment Coordinator for the Oregon Health Authority. I've been in this position for a couple of years now, just a couple of years this July, actually. Prior to that, I worked up in Deschutes County as a contractor for the county and for the law enforcement in resiliency and recovery types of subject matters. And prior to that, for about 12, 13 years, I was the Civil Commitment and Crisis Team Supervisor for Deschutes County. In addition to that, I'd also been the supervisor for Spokane County Mental Health Crisis Team in Spokane, Washington, and also was one of the first crisis intervention people in the state of Montana, in Kalispell in Flathead County. I'd also done civil commitment and crisis work in Seattle, Washington, working actually in the high-rises in Seattle, working with folks who were adjusting to a new population of people being brought into their high-rise living situations, and that was those folks who had substance abuse issues and mental disorders as a qualification for being in a high-rise, where prior to that it was primarily the aging population with the medical concerns. And so there was quite a cultural shift happening, and that created a crisis-related need for services there. And I was one of the folks who first went in and did that, which was fascinating work in the high-rises. So my crisis work really spans from very urban settings such as Seattle and Spokane to very rural settings in Montana, and semi-rural urban settings such as Deschutes County. And so I've had an opportunity to do this work in all those different settings and how it works when you have a lot of resources and when you don't have a lot of resources, and when you have a very intricate system and when the system is very fluid and or general, so to speak. And the different laws in Washington, Montana, and Oregon in terms of civil commitment processes and how they work and how people are trained. So I do have quite a bit of experience with this subject matter, and have, of course, throughout the years, the 40+ years of doing this, have really loved being in the field, doing the work in addition to supervising and program management and that sort of thing. So today what we're going to talk about is how best to work with the civil commitment investigator and the crisis worker in terms of partnering with them so that you get the best outcome you possibly can with the situation that you're facing. And these situations, of course, are very complex, and they require a lot of different perspectives to come into play to determine what the best steps to take, how to make them happen, and how to do them in such a way that the individual that you're working for is as much a part of the process as possible and participates in that process. But of course, safety takes the precedent over everything. When that is in play, then that has to be addressed first and foremost. So we'll talk about all those things. What I'm going to be showing you is the PowerPoint that I use to provide as a training for civil commitment investigators and examiners who have to be certified in this field. And I'm the person at the state who does that training. The training is usually a day and a half long. It used to be 2.5 days. Then before I came on, it went down to 1 day, which was too little time to do both pre-commitment and post-commitment processes. and I've expanded it out to a day and a half. And now we're in this new world of COVID and social distancing, and most of the training is now being done by Zoom. There's new opportunities and challenges to address the training needs for the state of Oregon with this process. So without further ado, again, thank you for having me, and I hope this conversation is of value to you. We will have a question and answer period towards the end of the talk. I hope to go for about an hour and 40 minutes or so, and leave about 15 to 20 minutes for questions and answers. So if I hit this button, we should show my PowerPoint. Where did that go? There it is. There it is. Okay. So this is my email address. You're certainly welcome to email me or phone call me if you have questions regarding this presentation or going forward. We're happy to take calls from folks. Sam Dixon and myself, who's my partner here at OHA. One of the things we really like about our job is being able to connect with the community and talk with folks about civil commitment matters and processes. Another part of my job, which I didn't mention so far, was I also take part in the certifications of hospitals, mental health centers, secure residential treatment facilities in terms of their certification as a facility. And what that essentially means is that we make sure that the hospitals and these other facilities and agencies are adhering to the statutes and rules that are required for them to have their certifications for those facilities. And a good portion of all of that has to do with the due process rights that are afforded every individual in this country and in this state in regards to these kinds of interventions that happen around civil commitment, investigations, and civil commitment itself, as well as post-commitment processes and supervision. So this is how you can contact me. Uh-oh, we are not forwarding. I do not know why the slide is not forwarding.
Terry, try to click on the PowerPoint and then try to, there you go.
Thank you. Thank goodness for support. There's a great example of the need for support for all these things that we do. So this would be the training schedule that we would go through. And we're going to go through the first 2 hours of it, essentially. But you will have access in this PowerPoint to the entire civil commitment process training outline. I decided to just give that to all of you so that you could use that as a reference if you have questions regarding the civil commitment process. Everything in there is basically based on statute and rule requirements, and so it might be a good reference for you down the road. So we're going to primarily focus on the custody issues relative to the civil commitment process. That's the point where the case manager for the individual and the community, the family members, the individual themselves, law enforcement, all come into play in terms of determining whether or not a person is going to meet the criteria necessary to have them placed in custody for an evaluation. And we'll talk about how that works and how it can work better. This particular slide, which you can't see, of course, in any detail because it's too small a print, is basically a flow sheet of the entire civil commitment process from initial custody all the way to a civil commitment hearing. So one of the things I tell the investigators as we start our training is that if you understand this slide, you understand the basics of how to do a civil commitment process. And each one of these arrows has a lot of information packed into them. So starting first with civil commitment history. And this is, I'm going to say very brief, but one of the things I want to point out too is that we're in an interesting discussion these days in our country around civil commitment rights and also the way we understand how we got to this place in terms of civil commitment. One of the things that I point out when I do the training is that up until the 1970s, it was a very different world for what happened when people who were felt to be different or not able to take care of themselves, what happened to them in terms of their civil rights and how they got placed into facilities. And there was a revolution around that, and good reasons for that too. And that has to do with the whole eugenics philosophy and history that was happening prior to the 1970s, you know, in the 1940s, 50s, and 60s. People who had mental disorders of one kind or another were lumped into very crude and poor categories. And then without very much due process rights placed into facilities, and again, without very many rights in terms of opportunities to be released from those places. There was a kind of a pseudo-scientific diagnostic formulation that they would use, and I won't go into the categories because they're very insulting. And everybody from folks with traumatic brain disorders, developmental disabilities, dementia type problems, and mental health problems, mental disorders such as schizophrenia and so on, psychosis, were all lumped together into three basic categories and then oftentimes placed into hospitals without much care or treatment. And this kind of institutionalization was very unhealthy for those folks. There was an awareness and understanding about that that came into being, and the ACLU, along with the Reagan administration, worked together to find a different way of doing this. And this was the beginning process of the deinstitutionalization that happened in our country back in the 1960s is when they started. And it was a force of understanding that civil liberties were being violated and that people were being inappropriately and unfairly institutionalized without any due process rights. And so this need for deinstitutionalization was seen on a political, legal, and civil level. Medically, at the same time, there were medications that were being developed that were helpful and in alleviating symptoms. And so that also offered an opportunity for better treatment. In addition to that, the Reagan administration was interested in reducing the funding to these big box facilities. And I started out my career actually going to Eastern State Hospital in Spokane on Cheney as an undergraduate. And from there in Seattle, I ended up being a discharge coordinator for the hospital or the mental health center in Everett, Washington, and went to the Fort Steilacoom State Hospital. And of course, now I'm here in Salem, and maybe a mile away is the Salem Hospital, OHA, or OHS. And so these hospitals have quite a history to them. And I think it is appropriate that we move towards deinstitutionalization and community treatment. What, however, did not follow in many respects, the deinstitutionalization was the needed resources for mental health centers to do what was needed in order to wrap around services so that they could maintain the safety for everybody who was leaving these hospitals and be able to provide them the needs that they had. And so there was a spike in homelessness that has continued to this day. That has created other kinds of systemic problems so we now begin to see an increase in incarceration rates for folks with mental illness. These are called aid and assist evaluations, which now occupy as much as 60 to 70% of the state hospital's capacity right now. That too has created some very significant issues. We also see that the civil commitment processes in the state of Oregon have, or civil commitment rates, I should say, have decreased about 20% over the last 30 years. We're now completing and having civil commitments of around 1,500 civil commitments a year. And about 10 years ago, it was in the 2,000 mark. And so if you look at the population growth that continues to go up, the incident rate of mental illness within that population is going to continue to increase proportionately. You also see that the civil commitment rates have gone down. And a lot of people are asking the question, is that a good thing? Why is that happening? And is there something more that we should be doing? And those are the conversations that I continue to have with the folks here at OHA in terms of how we're looking at our rules and statutes and what kind of adjustments need to be made there to make our civil commitment processes more effective and better targeted. So yeah, this slide basically just talks about the deinstitutionalization in terms of bed rates. And so you see a dramatic drop from 550,000 psychiatric beds in 55 to 200,000 in 1975. Here in the state of Oregon, we have 1,100 acute care beds and 147 adolescent beds for our entire population, which means this is a very important resource, a rare resource, so to speak, in terms of being able to access it. And so you can imagine the dynamics that get created when you have a resource as necessary as an acute care bed for a population that continues to grow, a civil commitment rate that keeps going down. And we have this resource that we have to manage very carefully because there's so few of them. And as a result of that, the acuity of the people that end up being civilly committed becomes higher, just by the nature of the resource management issues itself. I'm hoping that you understand what I mean by that, but as we have less resource and it is more difficult to get in there, the acuity of the person that ends up in there takes a higher priority over somebody who has the need but may not be at the same level of acuity of risk. As I spoke before, these kind of factors played a big role in terms of how things look now. We have new drugs that are more effective, oftentimes more effective, especially on the side effect side of things, and maybe a little bit more focused in terms of symptom management, as opposed to the first age medications such as Thorazine, Prolixin, and so on. Outpatient therapy and treatment is less expensive and very effective in many cases for folks. Reagan cut the federal funding. ACLU is also in favor of deinstitutionalization. There was a counter conversation, however, that also took place, offering a different perspective through the American Psychiatric Association at the same time. And what they were offering as a possibility was their emphasis was on the medical benefit of psychiatric care. They were suggesting and promoting a perspective that allowed our civil commitment statutes to be a little bit wider open so that we'd identify individuals who are in need of treatment and be able to leverage that treatment through the civil commitment processes prior to necessarily meeting a high level of acute risk of danger to self, danger to others, inability to care. That did not have the same traction as the ACLU's perspective that due process rights had been severely misused or not even addressed during the prior years, and that became the fundamental driver of the statutes that we see in each state across the country, was the need for due process rights to be very closely monitored and protected. And so these are the kind of concepts that the civil commitment investigator needs to understand in order to do their job properly. And that includes due process rights, which are baked into all of the statutes and rules in the civil commitment statutes and the Oregon administrative rules. Judicial day. We have to calculate judicial days as a way of timing when we file reports and when a court hearing takes place. And we'll go through those definitions individually. There is a legal definition for what a mental illness is. It is not the same as a clinical definition. So when we're talking about a mentally ill person from a legal standpoint within the statutes and rules, we're talking about somebody who meets a certain criteria of both having a mental disorder and due to that mental disorder is a danger to self, a danger to others, or unable to care for basic needs, and has been civilly committed. So when we're talking about a mentally ill person, we're talking about somebody who's gone through that entire process. Chronic mental illness, again, is not a clinical definition so much as a legal definition. And what that is a distinction between somebody who's going through the first civil commitment process versus somebody who's been through the civil commitment process or placed twice within the last 3 years. And what the legislation is trying to intend there is to acknowledge that there are some individuals who have been civilly committed more than once within the last 3 years, and that those individuals' disorder is so significantly impairing of their functional skills that they don't necessarily have to meet that higher level of acute risk to be determined to be somebody who is mentally ill. So in other words, their medical history is so significant that it shows a foundation to believe that person should be civilly committed if they're going down that same road where they've been civilly committed before, and you can substantially show that they are the same in that respect. And we go into a lot of detail about how to establish that criteria, how to present that criteria to a court, and what steps you have to take to make that happen. A mental disorder, again, is defined in a very different way than you might expect in terms of civil commitment processes. One of the questions people struggle with a lot is what mental disorders are qualifying mental disorders in order for an investigation to take place. And what surprises a lot of people is that the legislature did not define that in a narrow way at all. In fact, it was very broadly defined, and we'll talk about that too. Probable cause evidence is the lowest legal requirement of evidence in order for a person to be taken into custody, and that's the evidence necessary for custody. Probable cause is also the level of evidence necessary to go forward for a mental health hold, and probable cause is also the evidence to recommend a civil commitment hearing. However, once you get to the civil commitment itself, clear and convincing evidence is what's required in order for the court to find somebody to be a mentally ill person and be committed. Throughout the statutes and rules, less restrictive alternatives are required to be explored and utilized when appropriate. And so another way of putting this is that if it's a viable, less restrictive alternative, then that is and should be moved on as opposed to going to civil commitments. Civil commitments throughout the statutes and rules are considered to be the most restrictive and in some cases stigmatizing type of process that you can do to a person in their best interest in order to protect themselves and the community. But it comes at a cost. It comes at a cost of stigmatizing them. It comes at a cost of restricting their civil liberties for a significant period of time. Civil commitments are for up to 180 days, and they can be recertified more than once. And so you can have a series of civil commitments for that person where they are under this jurisdiction for over a year or more in some cases. The director's designee is the individual indicated by the director of the community mental health programs to be authorized to take somebody into custody. And so these are typically the crisis workers for any mental health center. So within any CMHP, there's going to be a group of people within the crisis team who are called directors designees. And directors designees do not have to be investigators, but they do have to be given some level of training and orientation as to what their authority is, how to use it, that sort of thing. Once one of these designees takes somebody into custody, it is only for the period of time for them to be evaluated at a hospital level setting in order for a physician or a licensed independent practitioner, as they're called, to make a determination as to whether or not the person should be held for a longer period of time. So the director's designee has a custodial authority, but it stops there with the custody. The pre-commitment investigator is the person who is certified by our office and through my training to then take over the evaluation of that individual who had been taken into custody, placed on a hold, and now is going to be evaluated by this investigator who has essentially what they call 5 judicial days going back up to the top, which are days in which the court is in session essentially, to determine whether or not a civil commitment is necessary or if there's any less restrictive alternatives that can be used to avoid a civil commitment. And then the examiner is an independent appointed person by the court. So they're appointed by the court. They're certified again through this office. These are individuals who have a number of years of experience working with serious and persistent mental illness. These are folks who are independent of the mental health center and provide an advisory role to the judge in the hearing of a civil commitment as to whether or not the clear and convincing criteria has been met in the instance of that particular person. And so they play a very pivotal role in the civil commitment process in terms of making sure that the due process rights are being adhered to, that the elements that are necessary for a civil commitment to take place are in fact present or not present, and also to make recommendations as to what should happen next. And of course, ultimately, it's the judge who makes a decision as to what happens in that hearing. That's kind of the skeleton of a civil commitment, the fundamental issues and necessary elements within a civil commitment. Of course, there's a whole lot more to it than just that. Here are two ways in which you can access online the civil commitment rules, Oregon Administrative Rules, and the Oregon Revised Statutes. Something to keep in mind in the difference between these two things: the administrative rules are made by the Oregon Health Authority, and they are essentially there to help detail and provide guidance around how to administer the Oregon Revised Statutes. They are not the law. They are the rules that are expectations on how things should go regarding these statutes. The statute is the law. It is has been developed by the legislature. The last major revision of these statutes for civil commitment was in the 1970s. And in developing those statutes that we now work with in 2020, so things have changed, and the statutes haven't necessarily always changed with them. But the legislature looked around at a number of different states and said, how are you looking at civil commitment? What do we like? And they took from different states and cobbled together their own set of statutes that govern the civil commitment process. One of the fundamental things we see in that all the time is the need to adhere to due process rights and to make sure that people's protections are in place so that there isn't any undue civil commitments, that people aren't being placed in hospitals without having an ability to have an attorney represent them, for example. Making sure that they understand and can participate in the process in any way possible. One of the other fundamental concepts underlying the civil commitment process is that capacity. There is an assumption of capacity for any individual who's going through this process to make medical decisions regarding their care. Now, I want to take a moment for that to kind of sink in a little bit, because we're talking about doing interventions with people who are thought to be a danger to themselves, a danger to someone else, or unable to care for their own basic needs, such that it may cause them to be seriously injured due to a mental disorder, but have the capacity to make decisions about their care throughout this whole process. There are times when that capacity is not felt to be present, and there are emergency situations where medical personnel can do medical overrides, provide medications and or seclusion and restraints when there is an emergency situation and somebody's health and safety is at risk. But it's only under those circumstances that that capacity is thought to not be there. In the rest of the time, that individual is given every opportunity to be engaged in the process, to make decisions about what they want to do, whether or not they want to go to a civil commitment hearing, whether or not they want to have a diversion from that civil commitment hearing, or whether or not they're going to simply stipulate to a civil commitment, be a voluntary patient, etc. So throughout it, there is an attempt to engage in a therapeutic manner with that individual to be a part of the process and to make decisions that are in their best interest and regarding their care and treatment going forward. It's believed, I think, underlying that, the idea that the more a person is engaged in their own care and treatment, the better your outcomes are going to be. And I believe that's true. I've also been a psychiatric security review board coordinator for a number of years in Deschutes County. And these are folks who have committed felony level crimes and have been adjudicated under this board to be supervised very stringently for the maximum term that that particular crime allows for. So in some cases, we're talking 20, 30 years of supervision with significant consequences if they don't adhere to the treatment plans. Even in those cases where folks had been in treatment under those conditions for years and had minimal or no medications and asymptomatic, it's been interesting to see what happens when they time out of that jurisdiction and are not, and no longer under the jurisdiction of the board, and then make decisions about their care. There's oftentimes some old patterns reemerge that seem to have been gone for many years. Excuse me, what that points to, for me anyway, is the real value of a therapeutic relationship and the development of the locus of control for an individual to be more internalized than external. So the more that you can get a person engaged and involved in their own care and treatment and work through their own experiences in a way that they feel like they are the author of their world, you're going to have better outcomes, even though it may be more difficult in some cases initially and off and on during out that period of time, because people make mistakes, as we all do, in terms of our self-care. So, mental disorder. Initially speaking, the legislature defined mental disorder as a person with a mental disorder. And that's redundant, I know. It's basically what they said is that it is up to the judgment of the investigator to determine whether or not that particular mental disorder is a qualifying mental disorder within the requirements of the statutes and within the requirements of the rules. So it also is a reflection of, at the time when you're taking somebody into custody, as a crisis worker, as you're working with somebody out on the streets, in the ER, or in the jail, wherever you might end up being, to do that initial assessment, there is a whole lot more you don't know than what you do know. There's many indications of a mental illness that can be attributed to different sources. So a person with a medical disorder may be presenting with a delirium, for example, and that delirium can look a lot like a psychotic disorder. There's certain qualitative differences, but you know that there's a psychosis of sorts going on, that there's confusion, there's disorganization, there's rapid talk, there's pressured speech, there's an inability to organize themselves in such a way that they can take care of their basic needs, or there may be an impulsivity that's very much present. But you're not going to be necessarily sure on the street whether or not that's a delirium or due to a UTI, or whether or not that's a brain disorder, somebody who's had a number of head injuries that could also look that way, or if this is a initial break of a psychosis, or if this is a drug-induced state, or an alcohol-induced situation, or a trauma-induced situation could also be the case. So there are many different mental disorders that look similar enough to each other that it's difficult to sort out on the street what exactly that is. And so the idea of a mental disorder is, for initial custody especially, is very broadly defined. And so the idea is that you take that person into custody if you feel like the risk factors are there, to a hospital where you can sort out the differential diagnoses in a more complete way and make a better decision as to whether or not this person should go forward within the mental health system or be referred out to other programs such as developmental disabilities or substance abuse programs, whatever the case may be. So there is a sifting process that happens, and it's very broad to begin with, and it becomes more and more narrow as you move more closer to a civil commitment hearing. So, as I said before, a person who is mentally ill means a person who, because of mental disorder, is one of the following: a danger to self or others. Okay, so again, dangerous to self or others is again very broadly defined, and as you look at the civil commitment case law that comes through the appellate court, which drives a lot of the way in which we understand how the legislature looks at this. The appellate courts are the courts that hear cases that are challenged by a person who's been civilly committed. So somebody's gone through a civil commitment, they've been civilly committed, and then following that civil commitment, they appeal that civil commitment. It goes to the appellate courts, who then review that case based on both the legislative language as well as their understanding of the intent of that language, and in prior cases similar to this, but they also talk about how each case has to be understood within its own particular nuanced characteristics. And when you're looking at danger to self or others, it shows that that definition is very broad. It just says basically somebody who is a danger to self or others. How that is understood is going to be on a case-by-case basis, both looking at the history, current behaviors, current risk factors, and what are those risk factors going forward after they've spent several days in a hospital in care and observation. And that has to be presented to the judge in such a way that it convinces that judge that this is a clear and convincing case that this person is a danger to self or others. So it's a very high bar in terms of determining that. However, sometimes there's been a lot of talk and conversation around what is the time frame of that dangerousness. And here the Oregon Administrative Rules have weighed in on that and talked about it being an imminent risk to self or others. And there has been some recent suggestion that maybe that be changed to a 30-day period of time as a way of broadening it out. I have my own particular point of view on that, but at this point, as it stands, dangerousness to self or others is defined on an individual basis based on that particular case and where that person's at in their treatment process at the hospital level going forward. Or unable to provide for basic personal needs that are necessary to avoid serious physical harm in the near future, and is not receiving such care as necessary to avoid such harm. This statute has changed in 2015, and it was first seen in case law in 2016, I believe it is, and it only became clear to us about a year and a half ago, but this has changed significantly in its language from what it was prior. The prior language for this was much more restrictive, where this person's health and safety had to be at immediate risk, where they may not survive. And so there was a concept that inability to care cases had to be at the point where the individual was so disabled medically or otherwise that if they didn't meet the civil commitment criteria, they would possibly die within the very near future. This particular statute has to have a medical opinion weigh in on it heavily. Without a strong and clear medical opinion on this particular point, it is very difficult to get that to go through in a civil commitment because of the medical qualities to it. Or a person who is chronically mentally ill. And again, we spoke about that just a little bit ago. And the chronically mentally ill person is someone who is defined as within the previous 3 years, twice placed. And placements are not the same as commitments, and that's often a misconception people have. So you can have somebody who's been civilly committed, gone through the civil commitment, and then a year later, again civilly committed with time in between, and that would be 2 placements within that 3 years. Or you could have that person who's been civilly committed and then revoked on his civil commitment and returned back to the hospital. That too would be a placement, and so that would also be a qualifying event within that 3-year period of time. Or you could have somebody who has been placed on civil commitment and recertified for another civil commitment towards the end of that first civil commitment, and that too would be a qualifying placement. So there's 3 pathways to having those placements count towards this chronic mental illness. The advantage of that is that you can have somebody who's exhibiting symptoms or behaviors substantially similar to those that preceded and led to one or more of the hospitalizations or inpatient placements. So that means that the individual can go through a period of stability and then for whatever reason begin to decompensate in their mental illness and begin to show the symptoms and behaviors that initially led to the first or the second civil commitment. And if they are of a substantially similar nature, you do not have to wait for that person to be at the acute risk level that they were initially at in order to take action and intervene in that person's behalf. And so that's something that where the case managers in communication with the crisis workers is very important, is being able to communicate where they believe they see their client to be at in terms of their illness, their decompensation, what kind of signs and symptoms are being exhibited that are the same or similar to what had happened in the past and previous commitments. That crisis worker or case designee can go into the history and see whether or not they possibly meet that extended criteria. And there might be some planning discussions that you can have about an intervention that doesn't require you to wait for somebody to get hurt or threatened in such a fashion that is unnecessary in order to take action. And so it's really important to have that communication with the crisis team around how you're seeing your individual doing, and if there's a decline in their health and their ability to take care of themselves, that is communicated. But it doesn't always mean that the individual that there can be action taken at that moment, but you begin to have a dialogue and a conversation and develop some clarity around when that could happen based on your understanding of the patient and that person's medical history. So one of the ways that the chronically mental ill status can be determined is by emailing myself or Sam Dixon. We then go into the state's database at the hospital, which records everybody who's been civilly committed for decades. And we can pull up their history within the previous 3 years to determine whether or not those placements have taken place. And we'll provide that information to the investigator as part of the evidence presented in court. And so this is kind of the gold standard, is getting us to get into the state's database, but that can also be determined in other ways as well, such as talking to the individual about their history, or a family member who has an understanding of their history, and or the medical history within the hospital. One of the questions that comes up around that is, what about civil commitments in other states? And I hadn't mentioned this earlier, but one of the things that's kind of interesting, I guess you could call it interesting, is that the statutes and rules as they apply to the state of Oregon do not have a reciprocal relationship with the state of Washington, the state of Idaho, state of California. Each state has very different ways of doing things. Some are more similar or less similar to others, but there is no reciprocity. So for example, if somebody is civilly committed in the state of Oregon and goes to Washington state, for example, there is no jurisdiction that transfers over to the state of Washington for that individual. Essentially, the civil commitment cannot be enforced while they are out of the state. Once they come back into the state and it's still within the civil commitment timeframe, then there's things that can be done. But if a person leaves the state under a civil commitment, it doesn't transfer. Also, somebody who's been civilly committed in another state and then comes to Oregon and say that civil commitment just happened a few months ago, that civil commitment does not count towards the chronically mentally ill requirement. The medical history, of course, is incredibly important in terms of understanding who this person is, how they respond to certain kinds of circumstances, what kind of behaviors they've engaged in. All of that is incredibly important in terms of understanding the client and maybe having some ability to look into what are the risk factors going forward and what has helped in the past. That's all very important, but it would not be a piece of information that would go towards that chronic mental illness requirement. Because again, the civil commitment statutes are different enough so from one state to another that they don't apply. So let's first talk about probable cause. It's one of my favorite quotes. I'm confident, but not really sure. This is from Tom Petty in the Heartbreakers in one of his great songs, and I think it says it just as well as the next ones do. But basically, we're talking about somebody who has a reason to believe something is the case, that there's a reasonableness quality to it. So substantial objective basis for believing that more likely than not a person is mentally ill, or a greater weight of evidence. This is the level of criteria that's necessary to take somebody into custody, as I said before. And so if you're working with somebody on the streets, you're asking yourself, do I have a reasonable belief that this person has a mental disorder? I don't have to know exactly what it is, but I do have to have a general sense of what that mental disorder is and what kind of behaviors and observations that I'm seeing or hearing that tell me that is the case. In other words, can I substantiate what I believe to be the case? And I have to have a reasonable sense that if another clinician in my shoes would probably come to the same conclusion, not necessarily the same diagnostic certainty, but the general understanding that this is a mental disorder of some type. So a greater weight of evidence is another way of putting it. The folks who do the folks who do custodies are police officers. They have the ability and they're given the authority to take people into custody, as we all know. They do that based on the same probable cause level of evidence. A director's custody by the designees, as I've talked to before, as well as the hospital hold and the day 3 report recommending a civil commitment hearing. In each of these things, you're leaning into the future. So for the police officer custody and the director's custody, you're essentially saying, as an investigator or a crisis worker, I believe this person has a mental disorder. I believe it's of this type, and these are the reasons why. And I also believe that if I get this person to the hospital, physicians probably, it's reasonable to assume that they are probably going to believe this person is going to meet hold criteria. And so you have to have a general sense that this person is going to meet that next level of criteria. The hospital hold is the same thing. During that evaluation process where you're doing labs and you're doing observation, you're doing interventions, you're finding out who the support systems are, all that sort of thing. And over that period of time, the LIP is getting consultation from the social worker and from the crisis worker, from law enforcement, all in order to come to a basic conclusion as to whether or not this person, at this point in time, as they are seeing them, and as they get this information, that this person probably would meet civil commitment criteria if they were to go to court right at this time. So this is, again, somebody who's at the peak of a crisis cycle, is not functioning very well, may have recently taken action such as an overdose or harmed themselves by cutting, or any number of ways that could happen. And based on what they are seeing and hearing right at that moment, they do not have any kind of less restrictive alternative that would protect that individual and protect the community at that point in time, and so they place them on a hold. And then there's further interventions that happen at that point too. At the day 3 report recommending a civil commitment hearing, the investigator has to have probable cause level of certainty that a civil commitment would happen if they were to go to court. And so in other words, they have done their investigation, they believe that they've explored all the options for less restrictives, and none of them are going to be protective enough or mitigate the risks enough. And that if this person goes to court right now, the judge would find that person to be civilly committed based on that particular circumstances of that individual. So here's the qualification. I won't spend a lot of time on this. On mental health professional, these are the folks who can be designated as director's designee by the director to take somebody into custody. And again, I mentioned these are the forms of custody that you have. You have the police officer custody, the director's custody, and the transport custody. Transport custody is a facility that is authorized through us or certified through us, OHA, to take somebody into custody for a period of up to 12 hours in order to transport that person from an ER to a hospital that has psychiatric care, such as a 5-day hold hospital or an acute care hospital. Now, again, this speaks a little bit to the due process rights. What's intended here when somebody's being taken into custody is for there to be a determination that this individual is at risk and that this individual has a mental disorder of some broad category. In the hospital, they are then looked at, and there's more of a differential diagnostic process that takes place. They rule out whether or not this is substance induced or whether or not this is a medical issue that can be managed through medical treatments such as a delirium or some other kind of a medical condition that is being exhibited through psychiatric behaviors or behavioral problems, and or whether or not this is a mental disorder that exists separate from all of those other issues and that needs a psychiatric intervention. Now, if it is concluded that that person has that kind of issue going on, that there needs to be intervention, there needs to be assessment, there needs to be ways to provide support to that person, all in the hope that this person can avoid a civil commitment. It is that person's right to have these interventions as a means to avoid the necessity of a civil commitment. So a transport custody is designed to take that person to a place where that kind of intervention can take place with the intention that a civil commitment is not going to be needed. So when a person doesn't have the ability to go to an emergency room, or to a psychiatric facility, they're in some ways having their due process rights denied them because they're not getting adequate care and treatment during this custody and hold period in order to avoid a civil commitment. And so that's why it's so very important that we get folks to the right place where they can get the right intervention so a civil commitment's not needed or necessary. And so that's why they're only allowed to hold them for up to 12 hours. However, that's not always the reality that we face out in the world. And one of the reasons that is say, for example, we have the state hospital currently has around 60% of its beds filled with what's called aid and assist clientele. Aid and assist clientele are individuals who have committed some level of crime and have been detained in a jail. And when their attorney, their defense attorney, is interacting with them, they find that that individual, because they believe a mental disorder is at play, is interfering and impairing their ability to assist in their own defense. And so they then go to the judge and they say, Your Honor, my client is, due to a mental disorder, it appears, is unable to assist in their defense. I recommend that they be placed at the state hospital for a period of time for assessment and what's the word for it, that they are able to recover that ability to aid and assist. The judge then so orders it, and in some cases they go to the hospital, they're assessed, found to not be able to aid and assist, and then they come back, and then they go to court again, and then they go back to the hospital for a period of time for care and treatment. In the most efficient way, the judge orders both the assessment and to retain them for that recovery period all in one piece. But in any case, they go to the hospital, and that could be it for up to a year. And so these individuals go into the hospital, at the state hospital, they stay there for a year, and then if they are able to be, their ability to aid and assist is recovered through care and treatment, they go back to jail, they then face their charges, and the process moves forward. If they're found unable to aid and assist in their own, or unable to be recovered of those abilities, they then go back to the jail. The judge then has a choice of either to release the person back out into the streets or to recommend a civil commitment hearing. And sometimes that's the case. But the point here is that these folks are occupying a great deal of the hospital beds at the state hospital level. What that means is that, and because now of COVID and the social distancing and that sort of thing, there have been a moratorium on civil commitment admissions into the state hospital. They are now starting to do that, but the waiting list is incredibly long. And so there's a backlist of folks who are in acute care hospitals who have been civilly committed, who aren't able to get to the state hospital, and that's been determined their level of care that they need is to go to a state hospital, long-term care facility, but those beds are not available. And so they then stay in the acute care hospitals, such as St. Charles, Sageview, for periods of time longer than what's intended for those hospitals to be there. And so as a consequence, the census gets higher and higher at St. Charles or other hospitals like them, and they're not able to admit people from these transport custody hospitals. That period of time gets longer and longer. It becomes a dilemma for those hospitals who have transport custody ability, but nothing else, on how to manage somebody who is in an acute psychiatric crisis, who is in need of medications, who's in need of intervention, social work, etc., but doesn't have access to that necessarily like they would in a hospital because there's no beds available at the acute care hospitals. And that's because there's no beds available at the state hospital. So you get this backflow that pushes all the way down into the community level. And that impacts, of course, the crisis workers and the case managers too. So again, you get back to that whole issue of the scarcity of the resource of acute care beds in a system that is designed to restrict those admissions for those folks who are the most, only for those folks who are the most in need of that, and that need is partly defined through dangerousness. So the hope in giving you this presentation around this is for you to understand kind of the dynamics that the crisis worker and the investigator are under in terms of being able to get successful civil commitments to happen, and also to get that person fit into the right care of system that is going to best meet their needs. When you have this constricted and restricted bed availability in those certain areas. So it becomes very challenging for that to happen. And when you have a scarce commodity like that, it becomes a challenge for everyone, and it can impact and cause people to think about that resource differently than they might otherwise if there was more free access to that resource. And we can talk about that in the question and answer phase more, but I wanted to just kind of give you the idea of the environment as it is in terms of both the legal issues as well as it is in terms of the dynamics of getting admissions to happen and what's required by the court in order to move forward into a civil commitment. And how the legislature believes that civil commitments are, again, the last resort, usually as a result of other treatment systems not able to work effectively for that particular person. So I already mentioned that, so I won't. So again, the officer's custody is to take that person to the nearest hospital, approved hospital or non-hospital, for an evaluation by a physician. That custody is in place until that physician makes a determination as to whether or not to hold them or release them. So that's kind of an interesting dynamic as well, because police officers, especially in rural counties, there may only be 1 or 2 officers that are on duty on any particular night, and it is very difficult for them to stay in a hospital while an evaluation takes place for somebody in an ER and the rest of the community is not being covered. And so they work out relationships, hopefully, with the ERs that custody is in place till the physician makes a determination, but they can be released until they are needed to come back, that kind of a thing. But that's oftentimes a point of conflict between the officer and the hospital as to having to stay in an ER for many hours while an evaluation takes place. I do know that Bend has a pretty good relationship that way with the officers, and have worked out such that the officer doesn't have to stay unless it's absolutely necessary and does come back. And they have security as well that also assists. But not every hospital has those kinds of resources. And that's the form that's used. This is the flow sheet. Takes into custody, transports to the hospital. MD does an evaluation, makes a determination of either holding or releasing. So pretty straightforward, right? Same thing with the director's custody. Here, the authority is for the director to request an officer or order a person who is allegedly mentally ill to be taken into custody by law enforcement. The thing that's important to note here is that when a director makes that kind of a request to an officer, it has to be followed through, but it is up to the officer's discretion as to how it's followed through. And what I mean by that is that if it is unsafe for the officer to intervene with that person at that particular time, for example, an individual who is locked into their home, has a weapon with them, says that if an officer comes to my house, I'm going to shoot him, or I'm going to have that officer shoot me. The officer's determined that it's unsafe to make that intervention at that point, especially if there's no other people in that home, no hostages or anything of that nature. They're going to figure out another way to do an intervention with that person as opposed to risking their safety or the safety of the individual for taking them into custody at that point in time. And so it's always up to the officer, the discretion as to how that takes place and when that takes place. But the CDMHP director or designee has that authority to take them into custody if they believe there's a mental disorder and there is a risk. And again, it's basically the same form as the physicians. And here's a probable cause scenario that I often work with the investigators who are getting certified to problem solve with me about at what point do they believe they've got the probable cause level of criteria met. So you have a white female in her 40s, reported to be in the streets. She's disheveled, appearing to be yelling at cars. And upon contact, you're called out there as a crisis worker. Your person's not oriented, distracted, generally uncooperative, smells of alcohol, mental status indicates a possible mental illness. Again, you don't know exactly what that mental illness may be. Says she's tired of living. Of course, that's a risk statement towards suicide that may or may not indicate a level of acuity. You don't know that yet. After speaking with a mother, she recently broke up with her significant other. She threatened to kill herself and then left the apartment. So now you have a triggering event. You have a recent threat of self-harm in addition to her statement of being tired of living. And you have this breakup. She has a history, according to the mother, of past attempts, not clear how, when, or why. So it's not known whether or not there's been a series of attempts leading up to now, or whether or not they've occurred years in the past. So it's not clear what that relationship to past attempts are to this current dynamic. This person's not a part of the mental health program, so you don't have a medical history that you can look at. The police report that drivers called 911 after having to swerve to miss hitting the subject. And this person refuses any kind of voluntary services and says, just let me do it. Again, indicating some intention of possible self-harm, but again, that's a vague enough and open enough statement that you don't know exactly what she means by that either. And this is the first piece of it. So this is what you know just within the first few moments of walking up and talking to the officers and hearing what they know and making an initial introduction to the female. One of the significant pieces, because we're not in a kind of an interactive format here in this presentation, one of the things I talked to the investigators who are getting certified, I say, what more do you want to know and from who that would lead you to the point where you feel like you've now crossed that threshold of clear or probable cause? And many of them eventually get to the point where they say, well, actually part of this is we already have information, objective information from the officers that people were swerving to miss this, hitting this subject. In other words, she was not just walking on the street, on the side of the street, she was walking out into the street such the cars were having to move around her, causing them attempting to not harm her, but also putting them at risk for possibly getting into accidents. Other investigators would say, well, that kind of depends. Is this a city street or is this a highway? You know, how busy is the streets? How fast are the cars? All these details do matter. And so what they're trying to do is sort out, how do I mix and match this information, this evidence that I have? What priority, what weight do I give it? What more do I need to know what I should do next? And another central question to this whole kind of scenario is, what are the chances that if I walk away from this with some referrals, that I'm going to get a call from law enforcement or from somebody that this lady is struggling or causing a risk situation just in the next 15 to 20 minutes. And from my understanding of this particular kind of scenario, the chances of that are very high. And so the question becomes, if I take action now, if I take her into custody, we do a containment of this situation, we do a better evaluation and assessment of what the alcohol levels are, what else is going on, get clarity on her statements of her suicide risk, we calm this whole situation down, would that meet the probable cause criteria that's necessary to take this person into custody? And in most cases, the investigators fall on the decision that, yeah, it probably would meet that probable cause criteria. Another scenario that we also talk about, this is a transient homeless person who gets into a verbal argument, pulls a knife on another person, and eventually the first individual shoots the second person. Police called the crisis team and informed them that they were ready to release as a self-defense, but wanted the mental health people to weigh in on the subject. This particular probable cause scenario came up while I was doing a training. Between the 2 days of the training, their crisis team had to go out on this very type of case. And what was happening here was there was a very cursory assessment of that individual's mental health related problem. And the police were initially thinking maybe they should let this person go, but they wanted the crisis team to weigh in on it on the phone to make a determination as to whether or not they agreed with the law enforcement officers. And so the lesson here is that when you are being asked to make a determination about probable cause for custody, you have to do that in person. You cannot make that determination over the phone, especially of a nature like this. It turns out this person was placed into custody and then eventually on a hold and then eventually civilly committed. It turns out that the clarity of whether or not this was a self-defense situation became much more murky as more details came in. And so this is also part of the challenge for a crisis worker and for a commitment investigator, is that you're given a lot of information, and that information has varying degrees of factualness to it. And so part of the job is to sort that all out. As a case manager, one of the things that really is beneficial for you to advocate for your client is to know this, is to know that what the investigator is looking for is for factual details about why you're concerned about that person's safety. Whether or not you see that person that you're working with is starting to decline in their ability to function, and what do you believe that's due to? For example, a decrease in medication compliance, missing medication appointments, a decrease in hygiene, or a change in their language structure, or an insertion of more paranoid thoughts or ideas that concern you because they're similar to what they were in the past when this person was much more ill. Or maybe there's a change in circumstance that has possibly precipitated these declines. And so if you can outline for the crisis worker what behaviors and symptoms you're seeing, what time frame that they occur in, and what has been the history that has led to more risk in the past, that gives the individual, the crisis worker, a much better framework from which to work with, as opposed to indicating that you're worried and concerned about this person and you want the crisis worker to do X, Y, or Z without giving the foundational information necessary for that to happen. And so what I'm hoping that this presentation does is kind of outline for you a little bit more clearly what they need to see and how their thinking process is and what the criteria is. As you can see, probable cause is fairly broad, but it does, excuse me, it does have to be based on the evidence, and that evidence has to be both observational, something that can be seen, something that can be pointed to, and have an actual result that other people can confirm, because that's what they're going to be expected to produce for the court if they go that far. Okay. So we talked about the 12-hour transport custody, pending to an approved acute care hospital. Again, that's a due process right. So that's what the physician is also doing. The physician's making the same set of determinations that the director's designee is making, so, or the law enforcement officer. So once they get that individual, they're now looking at that person to determine, one, is there a mental disorder, and two, does that mental disorder cause them to be a danger to themselves, danger to others, and are there any other mitigating or less restrictive alternatives to taking this person into custody? One, of course, is whether or not the person is willing to engage in treatment on their own. They have a level of insight that says, you know, I understand I'm really struggling here and I need to be in treatment, and I'm willing to be in treatment. And if that is a viable option, the physician determines that that individual is sincere in their understanding of their need for health and for care, and then they will possibly go with a voluntary basis. And that is a good way to go, I believe, and I advocate for that. If the person then changes a few hours later, their mind begins, once they start walking into a psychiatric hospital, for example, that's a very intimidating experience and a scary experience. So you don't know what's going to happen, especially if it's the first time, and or how things are going to work, and you're already not in a good state of mind to begin with. You may decide, no, I really don't want to do this. At that point in time, if the risk factors are high enough, the person could be placed in custody or on a hold at that time. But anytime you can get that person to, on their own volition, engage in that care and treatment in a viable way, it's in the best interest of that person to do that. But these are judgment calls that a physician makes in consultation with everybody else, and they're looking again at that same set of criteria. Now, the physician does have in their toolbox certain number of steps they can take. For example, there is a medical hold statute that does exist that allows a physician to take somebody into custody at the hospital for a 48-hour period if they believe they're incapacitated due to a medical condition or a substance-induced problem. And some hospitals do utilize that for those folks who come in due to a significant intoxication with blood alcohols that are very high. It allows them to be retained in the hospital until such time that they sober up to the point where an investigator can come in and do an investigation, do an interview, and make a better determination as to whether or not a mental disorder is present. So many of the crises that we see across the state are temporary, short-term, very intense, but they don't last very long. And sometimes that's due to intoxicants and other kinds of situational stressors that are short-term or temporary. And so you see significant changes between what's in the community, what happens in the emergency room, and then what kind of interview you have a day or two later. And this is why you see across the state the general average of, if you have 10 people who are taken into custody, of those 10 people, only one of them is going to end up on a hold for a period going forward. Those 10 people who are placed on a hold, only one of them is going to end up in a civil commitment. So you get essentially a very small number, about 17 to 14% of all holds end up in civil commitments. And that's been true for decades. And so you get that filtering process that happens in terms of less restrictive alternatives and other options in place, where only those folks who simply can't be intervened in any other way end up in civil commitment. And this is the transport form or flow sheet. Basically, again, what we talked about. A non-hospital facility, by the way, is simply a hospital that's certified through OHA to provide psychiatric care, but is not actually attached to a hospital. So they have the same abilities to do emergency medications and emergency seclusion and restraints, but they are not a part of a hospital. Acute care psychiatric unit would be, again, like St. Charles, who is part of St. Charles Hospital. An example of a non-hospital facility would be Juniper Ridge in the John Day area. Okay, and here is the comparing and contrasting of a transport custody versus a hospital hold. And as you can see, there are differences in terms of what is available to that person in a transport custody. And the custody is, again, required only lasts for 12 hours. And so not much is happening there other than kind of a containment and stabilization before they can move over to the hospital where they are given these treatment options. Okay, this is my this is my shepherd and my mastiff, and it would be break time around 10 o'clock for these folks, but we're going to continue soldiering on. I think they do a great job of showing what a break looks like. But anyway, so the investigative process. In this section, basically we talk about how an investigation is initiated. This happens when a person is, a mental health hold is initiated by a licensed independent practitioner, usually a physician in the emergency room. Once that decision is made, there's what's called a notice of mental illness filed with the court. That notifies the court that one of their citizens has been taken into a hold status and is being held in an acute care hospital against their will for a period of time until they determine whether or not, the hospital determines whether or not to recommend a hearing through the investigation or to be released in some fashion. But it allows the court to know what's happening with their citizen, and it puts a timestamp on the process. And also interesting to note, when COVID pandemic measures were taken here in the state of Oregon back in March, there was a lot of issues around court hearings and what was going to happen with all of these different kinds of court hearings that were taking place. Would they be delayed? Would they be pushed out? And the vast majority of court hearings across the state were in fact delayed and pushed out, and then the docket was changed in order to kind of retool for all the requirements for social distancing, etc. An exception to that were certain kinds of felony-related crimes and civil commitments. The Attorney General of the state said, you know, we're going to continue to have civil commitments as they are intended, in the timeframes that they are intended, and they are prioritized. And so it's an indication to some degree of the level of seriousness that these kinds of cases have for the court system and for our society in general, and how much emphasis is being placed on making sure those due process rights are maintained. In that case, the court said, you know, they're going to still have their hearings within that timely manner. They may be done within a video conference. There may be individuals who are only interviewed over the phone, which is the case. OHA relaxed some of our restrictions on face-to-face evaluations, allowing for video conference evaluations or phone conversations as is necessary in order to meet the requirement of working with that or interviewing with that person, but maybe not being able to do it in person because of the social distancing requirements or the hospital requirements to maintaining safety within their units. At any rate, still those hearings took place within 5 days, unless there's some sort of extension requested for that person. And so people did what they had to do to make sure that it got done within the time frame necessary, so that individuals who were under these investigations did not languish under them inappropriately. Here's the certification requirements for a civil criminal investigator. They have to be recertified every 3 years. They can do that either through CEUs that are approved by me or by attending my class on a 3-year basis. So things that an investigator has to do, they have to determine any kind of less restrictive alternative, as I've said. Those options are voluntary placement, a 14-day diversion from commitment. This is something that can take place on or before day 3 of the investigation. So remember, the investigations are for 5 judicial days, which are days the court is in session, and that means that a holiday or a weekend does not count as a judicial day. So somebody can be taken into custody on a Thursday, placed on a hold on a Friday, and the first judicial day wouldn't be until the following Monday. Unless it's a holiday, then it would be on a Tuesday. So it could be theoretically possible for a person to be taken into custody on a Thursday, placed on a hold on Friday, and not have their first judicial day count until Tuesday, which means their 5th judicial day wouldn't be until the following week, Monday. So it's very important that the individual who's being taken on a hold be well informed as to what their rights are, what that hold means, and what judicial day means in terms of hold processes, because it can be very confusing. And for an individual who is struggling under a psychiatric crisis, it's very difficult for them to process all of this. And for that reason, they have to have their rights posted in the hospital. They have to have their rights given to them verbally in the hospital, and they have to have access to that information periodically throughout their hold process, because it's understood that an individual's mental state is going to change from that high acuity of risk and confusion and whatever else might be going on to a more stabilized point where they can process these things more efficiently. But by day 3 of that judicial process, they can be offered what's called a 14-day diversion from commitment. This is a voluntary diversion option that is offered to some individuals in this process by the investigator, because they and the physician and the treatment team believe that if this person gets a couple of days of treatment and care, and they believe this person will engage in that in a therapeutic way, the chances are good that they will compensate from their illness sufficiently that they no longer meet the civil commitment criteria and can avoid being committed. This is, again, in an effort to engage that person therapeutically in that process and to avoid a civil commitment, which has all of those negative additional consequences to it, such as the stigmatization and the restriction of rights. And so it's an attempt to provide an alternative to being committed. So that individual can stay for up to 14 days. At any time in that 14-day period, that person can change their mind. And again, it's very helpful during this whole investigative process that the treatment team, including the therapists and especially the case managers, in my view, have contact with that individual while they're in the hospital, if it's allowed or if it's appropriate to do so, to engage that person, show that person that there's still a part of a group of people that care what happens and want to plan for moving forward, and also your insights and judgment as to how that person's doing to the investigator can be incredibly valuable, as well as to the physician in terms of what the environment was like for that individual out in the community, what kind of things, what kind of dynamics were happening that led to the initial hospitalization, so that the hospital and the physician especially has context to understand who this person is, both in terms of their history and their medical care, and also what their social situation was. And also, again, for the individual themselves to feel like they are connected and that they haven't been abandoned or just placed away in this hospital and have the fears that you know, they're never going to be released, et cetera. I mean, it can be, again, a very scary place for an individual to be. And these kinds of connections from the case manager can be very helpful on a number of different fronts. So I highly recommend and support those kinds of conversations going forward with the investigator as a person is being looked at for civil commitment. Other options are guardianship. And for folks who are dealing with long-term disabling mental illnesses, and it is not expected that the compensation around that is going to be to the point where the person is not going to need ongoing supervision and support, both financially and medically in terms of making decisions, a guardianship may be appropriate. Of course, most of you know that that's easier said than done in terms of determining who a appropriate guardian would be, and also financing that guardianship. And so one of the things that I talk about investigators as they look at that as an option is, do you have a viable guardianship situation in place? In other words, do you have somebody identified and also financially able to move forward with that guardianship, and that would be a good relationship for that individual that you're investigating? And so if that is the case, you could request an extension of the civil commitment process to see if and explore whether or not a guardianship could work. So if it's a viable option, it's something that can be done fairly quickly within the next week or two, you can request an extension, and the court almost always grants extensions when it's a viable attempt to avoid a civil commitment hearing. Another option is to discharge that person because for whatever reason they have substantially compensated to the degree that they no longer are either a danger to themselves or others. They may still be having mental health problems, but those mental health problems are no longer driving that person towards some form of self-harm or other harm issues, or that there have been some mitigating things put in place, again, with the help of the case managers, figuring out ways to change the environment that they would go out into, where their supervision or their care or their resources would change, such that they no longer would be meeting that unable to care for basic needs. So much, again, hinges on the ability for that individual to accept that care and be able to follow through with those offers of care so that it would be successful. Not just that it's available, but also that the person will be able to accept that care. Assisted outpatient treatment is another option that happens at the point of the hearing. So AOT and conditional releases, these are two less restrictive alternatives that happen at the court hearing level. AOT is essentially a process that is not civil commitment, but is a supervised release, but the supervision is done essentially by the judge. In other words, the judge has agreed in this case that this person doesn't meet civil commitment criteria, does need to be under supervision, and if they don't have that supervision, may decompensate to the point that they do become a person who meets that criteria of civil commitment, and also would agree to and follow the advice and authority of a judge. And so the judge agrees to meet with that person every 3 months or so. And the judge also orders that that person attend treatment through the mental health program. There are no funds or services that are applied to the mental health programs, and so there's no extra funding that goes along with this, and the mental health programs are not required to provide these services, but they can offer them. And so typically what that means is the person is offered outpatient therapy, medications, and case management, whatever those needs may be. But if the person doesn't follow through with those things, it doesn't result in a revocation like it would an actual civil commitment. But it may result in a talking to by the judge 3 months down the road. So yeah, it's a fairly narrow group of people that this works with. There's a recent SAMHSA article that shows the state of Oregon is in the bottom third of effectiveness in terms of the way our AOT programs are built right now. And that's because there really isn't any mandatory funding or services provided by the mental health programs when these folks are placed under AOT. Conditional release is essentially a trial visit type of situation, only that trial visit situation is for those folks who go to the supervision of a family member or an adult that the court has determined to be a good person to supervise the individual. And so essentially it's a supervision usually by a parent, but it could be some other family member, or it could be even a friend in some cases, although it's very rare. In fact, you don't see conditional releases too often, but it can happen. And then the mental health center program will follow that person and provide treatment needs, but it will be all kind of under the care of and supervision of a family member. So again, kind of a rare circumstance, but it is a less restrictive alternative to a civil commitment. Okay. So we're at around 10:30. What this piece now talks about is the investigation of the person in custody, how that happens, how often they need to make face-to-face contact, that sort of thing. And I'm thinking at this point at 10:30, if there are enough questions that are more focused on the case management relationship to the investigation process, I think at that point we should probably go to questions. How do people feel about that?
You do, Terry, you do have a few questions in the Q&A box.
Great.
Unless we have folks weighing in on the chat box, I think it's not a bad idea to do some questions.
All right.
So first question from Vion. Forgive me if I just messed up your name. It's lovely, Vion. Question, does placement mean only in the state hospital or any IP psych unit or an SRTF?
Great question. So a placement does mean any of those facilities. So you could have a placement in a hospital. It does not just mean the state hospital. It can be any acute care hospital. So a placement is essentially somebody who has either been civilly committed, and that civil commitment can take place in a state hospital, psychiatric unit, or an SRTF level 1 or 2, because they're both locked, both capable of doing, well, the SRTF is capable of doing medical overrides and seclusion restraints. The SRTF level 1 is still a locked facility, but all of that other stuff has to happen at an ER level. But in either case, you can be committed to one of those places, and that would be a placement. Another way of understanding placement too is that when you go from a less restrictive setting to a more restrictive setting, such as a revocation of a trial visit, that's also called a placement. Or if you extend that person's restricted rights under a commitment by doing a recertification, that's also considered a placement that qualifies as extended criteria. So the answer is yes. All those facilities do work.
Thanks for that. And sure. Melissa T asks, just want to clarify that the placements for expanded criteria does not include aid and assist hospital placements. And correct. Melissa had another question as well that didn't make it into the Q&A, but first question first.
Yeah, so Melissa's correct. Aid and assist processes are separate and not connected to the civil commitment processes in terms of legal ramifications of them.
And Melissa's second question was about the definition of director hold. Director of what?
The director or the director's designee is what that's referring to, is primarily the director's designee.
And that would most likely be a hospital situation?
Yeah, so again, that term can be kind of confusing. So a director's custody, for example, is that person who's a director's designee who's allowed to take somebody into custody. Custody doesn't have a time frame associated with it. And basically what it means is that period of time it takes to go to taking them into custody, transporting them to an emergency room or some place where they can be evaluated by a LIP, licensed independent practitioner, or physician. And that's a director's custody. A director's hold is when a director or a director's designee, in conjunction or in consultation with a physician at a non-hospital facility like Juniper Ridge, can determine that that person meets hold criteria and can be transported to that place, that non-hospital facility. So these things are, director's hold applies to non-hospital facilities. A physician's hold applies to those facilities that are based in a hospital. So that's the distinction between the two. So for a director's hold, there is a filing of a notice of mental illness, just like a physician's hold, and you start the judicial clock, the 5-day clock, but that person is placed in a non-hospital facility versus a hospital facility. Happy to take a follow-up if that didn't make sense.
Well, Melissa wrote in again regarding director's custody has to be done with an in-person assessment. Due
Yes.
to COVID restrictions and limiting face-to-face, can we do it if we do an assessment via FaceTime or some other modality? Oops, Melissa T, that wasn't your question. Wow, Melissa. Okay, well, let's answer the COVID piece first, and then we'll figure out the other details.
So can you do a face-to-face by virtual means? Is that the question?
It looks like that to me. I'm sure if we miss it, Melissa will let us know. She'll redirect.
Okay. Yeah, so we have made a relaxing of the requirement that the face-to-face requirements for both the initial custodies and for the investigation be relaxed to allow video or virtual types of interviews or even phone interviews if necessary. So basically what we would say is that it is possible to do it that way if that is your only alternative, your only way of making connection to that person. I would not use that unless that's the only option you have.
Okay. Melissa, would you write into the Q&A if you feel like your question was sufficiently answered? And then we did have a question about, from Scott Burry. This is not a similar process, or is there a similar process for kids?
So that's a great question, Scott. Civil commitments does not make a distinction. The statutes and rules don't distinguish between adults and adolescents, kids, seniors, etc. In other words, any person of any age could be possibly somebody who becomes part of a civil commitment process. The most common way that occurs is, say, an individual, an adolescent, for example, comes into the emergency room and there is no parent or guardian available for that person to make any decisions about that care of that person at that time. And so there's an initial discernment that this person's a danger to self, danger to others, and unable to leave because of that issue, has a mental disorder, but there is no parent or guardian or somebody who can make that authorization happen for custody or for a hold. And so that person can be placed on a hold initially until the parent or guardian or DHS can come into play and take over that guardianship capacity. And at that point, the hold is then released. And so on occasion, you do see initial holds taking place until that guardianship or that person can come in and take over that authority. Another scenario that can occur that way too is that if for whatever reason the guardian, the parent, whoever that person may be in disagreement with the recommendation of the physician. And the physician may be arguing that the person, in their view, is a danger to themselves or others, should not be allowed to leave, that the circumstances under which it's being recommended that they leave by that person is not appropriate or unsafe, and so they're wanting them to stay. The guardian is refusing to give that authorization. Under those conditions, an initial hold could be placed, DHS then contacted, and then the DHS person could come in and make a determination as to whether or not they want to take emergency guardianship or work with the parents. Usually these things, almost 99% of the time, are resolved such that that's not necessary, but that could happen that way. And finally, for these reasons, it is extremely rare. I'm not aware actually of an individual, an adolescent or a child going all the way through the civil commitment process, because there's always another body who's able to, or agency who's able to take over that kind of authority to make treatment decisions.
Thank you for that. And since we're talking about special populations, I'd just like to throw in a question regarding the older adult world. We're seeing a lot of older adults with comorbidities of seriously and persistent mental illnesses, and now they're aging to the point where maybe we have some cognitive issues going on as well, and folks are having a tough time teasing out what's dementia and what could be part of an illness. And I don't know if you have any words of wisdom to speak to that, or if you could give us your general impression of, are you seeing more older adults that are being placed in civil commitment? I just like your general thoughts, and then some discussion around the dementia piece.
Great. So I don't know if I can speak to whether or not there have been more people placed under civil commitments in our state recently who are seniors. Part of the issue, again, as I spoke earlier, there is a huge capacity problem with as far as specialized beds for people, the aging population with mental disorders. There's only, I think, one hospital right now who's currently able to take folks in that regard. And so the other group, they have to function within the adult units, and that's difficult to do. So in terms of fit and needs that are somewhat different between the aging population and regular adults with mental illness. So that's one challenge right there, is just the capacity for the system to take in folks for civil commitments. Civil commitments with the aging population is very challenging because of the complex medical and comorbidity of different influences on that person's mental state, the interventions that are required to address those issues, and the availability of those interventions within the psychiatric hospital world, and also the long-term nature of the illness and the deterioration kind of impact of cognitive decline, in addition to a person who has a mental health problem, in addition to the social challenges that they face, and so on and so forth, financial, etc. So these are very challenging circumstances, and oftentimes it's not felt that everything is being met or the needs are being met adequately. Having said all that, these are the same challenges that the investigator faces, as well as so does the hospital personnel who are making these decisions about what is your primary, secondary, tertiary diagnostic category, or another way of putting it, what's driving what. Sorting that out can be very difficult, and one of the ways that investigators try to do that is they try to get an understanding of timeline and what was the baseline level of functioning prior to the onset of more acute symptoms. So say, for example, if a person does have an established psychiatric history say of schizophrenia with an onset in their 20s and continued on into their 40s and 50s, and started to show cognitive declines, which are also associated with schizophrenia and other psychiatric problems. But this appears to be more of a dementia-related or an early onset of dementia. And so you have these symptoms kind of overlaying the psychiatric symptoms. Say the person has been generally stable on medications during a period of time prior to this new onset. And these symptoms are essentially the same as what they were in past acute situations. However, you also now have the cognitive issues such as memory, concentration, focus, things of that nature that are more associated with the dementia process. So the question becomes then, does these new symptoms from the dementia or the dementia cognitive decline, are they impacting the schizophrenic symptoms or the psychosis in a negative fashion? They can sometimes be protective and sometimes they can be very much a negative impact on that person's illness. But in this particular scenario that I described, you're looking at somebody with a psychotic disorder who has an overlay of dementia problems. The opposite of that can also occur where you have somebody who does not have a medical history of psychiatric issues, but then develops cognitive decline, dementia, and maybe that dementia includes a psychotic process. If there's no initial or historical history of a person with a mental disorder, and now they're having these kinds of symptoms, you might be more inclined to diagnostically push that more towards a dementia-related problem. That does not mean they're still not having psychiatric or psychotic experiences, but it means you may be treating them or your expectations may be different in regards to what is the appropriate course of action to take. So again, it's that sifting process where you start out in the field and you don't know as much as you'd like to for sure, and you know enough to make sure that you get the person involved in a hospital setting. Then more tests are done and more rule outs are done. And then hopefully you come to a clearer picture of what's primary and what's secondary, what's driving what. But this is a complex conversation that has to be taken on a case-by-case basis. And it is not impossible for these folks to go through a civil commitment process if it's appropriate to do so, and there's no less restrictive alternative, and there appears to be a benefit for it to happen. But keep in mind, somebody with a brain disorder such as dementia may not fit or do well in a psychiatric setting and may be able to be managed in a different environment more effectively and have a better care experience than if they were in a psychiatric hospital. So those considerations also take place too. So I don't have an easy answer for that. I am saying it's very complex and requires a coordinated, hopefully a cooperative conversation with all the different people that are involved with this person, from family members, physicians, case managers, therapists, hospital physicians, the investigator, etc.
Thank you for that. That was helpful. We have another question from one of our anonymous attendees who asked, when does day one of a 2-day physician hold start? Is it when the paperwork is signed, or is it when they were checked into the ER? So
great question, and that's something that all the mental health centers and hospitals try to be consistent about. And the way the Judicial Day One is statutorily defined, it is, in fact, it's in my PowerPoints here somewhere. Let's see. There it is. The time of the within which an act is to be done as provided in the civil and criminal procedure statutes is computed by excluding the first day and including the last. So if a person goes into a hospital on a Thursday and it's determined that they are going to be held, and it would be the next day, Friday is the full judicial day, and that's when the filing should have taken place on that first judicial day, which would have been the Friday. So it's the next judicial day after the event itself, excluding holidays and weekends. And again, it's a 5-day process. So the intention behind that is that the individual be given a full evaluation period. And the idea is that if you start the judicial day count, say late in the day on a Thursday, say 4 o'clock, that person really doesn't get a full day of evaluation on that Thursday, and the clock is started early. It also makes it shorter for the investigation period as well, and so the investigator has less time to do a full and proper investigation if it's shortchanged that way too.
So Terry, we're talking about a work day defined as what, an 8 a.m. start? Or are we talking about 12 a.m. is when the clock starts ticking?
At work day,
Yeah.
when court is in session.
Okay, that makes sense.